Hi, everyone. Welcome back to A Clause for Concern, Notwithstanding Canada's Charter. In this final episode, we cover the use and contemplated uses of the notwithstanding clause in Canada's western provinces. We start by talking with Doug Stollery, an Alberta-based lawyer who early in his career acted as co-counsel in Vriend in Alberta, a landmark case from the 1990s that recognized a provincial obligation to protect individuals from sexuality-based discrimination. Doug shares his experience of litigating the Vriend case up to the Supreme Court of Canada and walks us through the period after the decision was released, when the Klein government considered invoking the notwithstanding clause to override the human rights protections affirmed by the court. Doug also shares the lessons he learned from these experiences, lessons that are especially poignant today with certain Western provinces now using or considering the notwithstanding clause to avoid judicial scrutiny of laws impacting the 2S LGBTQIA+ community. With the precedent of the Vriend case in mind, we finally turn to Saskatchewan, where the notwithstanding clause was recently invoked in Bill 137, also called the Parents' Bill of Rights. To dive into this, we talked to Jack Saddleback, an advocate with TransSask who takes us through the impacts that this legislation has on trans youth in the province, the ongoing constitutional challenge against the law, and the conversations and community building that has taken place in response to Bill 137. Hello, Doug. Welcome to the podcast.
Thank you. Thanks for inviting me.
So, Alberta's relationship with the notwithstanding clause has thus far been exclusively tied to matters of gender and sexuality. Can you maybe give listeners a sense of the challenges faced by 2S LGBTQIA+ community members in Alberta in the 1980s to 1990s?
Sure. Maybe we can start a little earlier. Same-sex relationships were decriminalized, or at least partly decriminalized, in 1969. But even following decriminalization, discrimination against members of what we would now call the 2S LGBTQIA+ community remained rampant. And through that early period, it was the policy of the federal government to root out any employees who they believed to be gay, a period of time called the LGBT purge. And in the 1960s, the government even used some equipment that they called the fruit machine to try to determine whether an employee of the government was gay or lesbian. Speaking to my own experience, I was born in the early 1950s and grew up in that world. And when I went to university in the early 1970s, no one was out of the closet. To be out of the closet at that time essentially meant that you were unemployable. And you risked being ostracized by your family and your friends and your colleagues. And at that point, when I was at university, there were no supports, there were no organizations, and there were no role models. So by the early 1990s, in other jurisdictions, they had started to provide some basic human right protections on the basis of sexual orientation. But that was not the case in Alberta. So, in answer to your question, in the mid-1990s, in Alberta, discrimination against the 2S LGBTQ community remained rampant. And many members of that community remained in the closet because to come out of the closet meant that essentially they couldn't get a job.
So how did the Individual Rights Protections Act come to be? And why was sexual orientation excluded as a protected ground?
Right. Well, maybe we should again start back a little bit further in history. You had the Universal Declaration of Human Rights in 1948. And in Canada, you had the Canadian Bill of Rights was passed in 1960. So this was sort of the start of the human rights movement in Canada. And over the 1960s and 1970s, provinces across Canada began enacting and then expanding human rights legislation. In Alberta in particular, in 1971, we had a new progressive conservative government after decades of social credit governments. That government was led by Peter Lougheed, and the first bill of the new government was the Alberta Bill of Rights, and the second bill passed by that government was the Individuals' Rights Protection Act. And it provided human rights protections on a number of grounds like race and age and sex. It didn't provide protection against sexual orientation discrimination, but at that time, neither did legislation in other provinces or countries. In 1977, Quebec added sexual orientation as a prohibited ground of discrimination in its human rights legislation, and a number of provinces across the country followed suit over the 1980s and early 1990s. But the Alberta government continued to exclude those protections, despite that progress in many other provinces, and despite the recommendations by its own Human Rights Commission in a report called the Dignity Report that said that sexual orientation should be added as a protected ground. Why? I think it really all came down to politics. A faction of the base of the party viewed being gay or lesbian or bisexual as an immoral choice. And there was concern by some within that faction that protecting people from sexual orientation discrimination would in some way undermine the moral fabric of society. I think that was the underlying philosophy.
Let's move to discussing the Vriend case itself. Can you tell us about the events that led to Delwyn Vriend's challenge against the Alberta government?
The facts are pretty straightforward. Delwyn was a lab instructor at King's College in Edmonton, and in 1991, he was fired because he's gay. So he complained to the Alberta Human Rights Commission, but he was advised that they could not accept his complaint because the legislation, human rights legislation, did not include sexual orientation as a protected ground, and because they had been instructed by the government not to accept cases based on sexual orientation discrimination. So Delwyn sued the Alberta government for a declaration that the refusal to include sexual orientation protections contravened the equality provisions of the Charter of Rights and Freedoms. And he sought a remedy that the court read in sexual orientation, meaning effectively seeking a court order amending the act to include sexual orientation as a protected ground against discrimination. So those are the basic facts.
The Alberta Court of Appeal decision in Vriend is infamous for all of the wrong reasons. What happened at the Court of Appeal?
We won at the Court of Queen's Bench. So we were the respondent in this appeal. The case was heard by Justices McClung, O'Leary, and Hunt. Justice McClung was presiding, and when Sheila Grekel, who was the lead counsel in the case, started her argument, Justice McClung swung his chair around and faced the back wall so that Sheila had to argue to his back and so that he would not have to look at us while we made our argument. And I passed a note to Sheila saying, my sense is things are not going well. And in fact, things were not going well. We lost that case 2 judges to 1. 2 judges of the Court of Appeal finding that the exclusion of sexual orientation from the legislation did not breach the Charter. Now, you mentioned the decision being infamous. In Justice McClung's decision, there were a number of statements that are of concern. In his judgment, he included reference to Jeffrey Dahmer, Paul Bernardo, and Clifford Robert Olson, all of whom were serial sex murderers. And one wonders what on earth that had to do with the case of someone who was fired from his job because he was gay. He said that it was not to be expected that majority rights, RIGHTS, would curtsy endlessly to minority rights, RITES. suggesting that sexual orientation is some kind of right, F-N-R-I-T-E. He referenced being gay as an alternative lifestyle, and he included a quote about an old decision of the United States Supreme Court upholding slavery. And the quote about that decision was, "I'd rather trust my dinner to my dog than this case to the Supreme Court," which we certainly thought was a very odd statement for a justice of the Court of Appeal to be making in the judgment. And after we lost this case, the Alberta government then sought costs against Delwyn Vriend personally, and were successful in a judgment, again, 2-1. The dissenting judge, Justice Hunt, said that even though Delwyn Vriend had lost the argument before the Court of Appeal, and even though he had not sought costs against the Alberta government, she nevertheless would have ordered costs in favor of Delwyn Vriend rather than the Alberta government. So that's what happened at the Court of Appeal.
So after that appalling experience at the Court of Appeal, Delwyn and counsel pressed on to the Supreme Court of Canada. Can you walk us through the experience of presenting this case at the Supreme Court and explain what the court ultimately decided?
Sure. So the case was held on November 4th, 1997. And we arrived early at the court, and we were the first into the courtroom. And we found on every seat in the gallery an anti-gay pamphlet. So before starting our argument, we had to pick up and throw away every one of those pamphlets. I have no idea how someone got into the courtroom to do that. And I have no idea who was responsible. And obviously that was a pretty unnerving experience to start off the case. However, the hearing went really well. All the justices of the Supreme Court of Canada listened carefully. No one faced the back wall as we argued. And Sheila, who did the initial argument, none of the judges asked very few questions of her. They just sat and listened intently. Following her argument, the government of Alberta argued, and the court gave counsel for Alberta a very difficult time. One of the arguments that Alberta was presenting was that the legislation wasn't discriminatory against gays and lesbians because gays and lesbians could access rights under the Act under other grounds, just not sexual orientation. And they referenced, for example, the AIDS pandemic and said that a gay man could complain about discrimination based on disability. To that, Justice McLaughlin stated, "So you have to get AIDS to get protection?" That's sort of a sense of the tenor of the way the case was going. The decision of the Supreme Court of Canada was rendered on April 2nd, 1998, and the court was unanimous that it was unconstitutional for Alberta to exclude protection against sexual orientation discrimination in the Individuals' Rights Protection Act. One of the judges had passed away between the hearing and the rendering of the decision, so there were 8 judges remaining. And 7 of the 8 judges found that the proper remedy was to read sexual orientation into the Act everywhere that other grounds were mentioned.
Although the Supreme Court ruled in Delwyn's favor, the court expressly noted that the Alberta legislature could overrule the decision by invoking the notwithstanding clause. How intense was the public pressure on former Premier Ralph Klein to use the notwithstanding clause to override the Supreme Court decision? And how quickly did organized campaigns spring up to lobby for using the clause?
Well, immediately after the decision came out, Ralph Klein said that he was not going to invoke the notwithstanding clause. But the pressure began right then. And it would appear that while we were waiting for the decision of the Supreme Court of Canada to come out, some groups who were afraid, concerned that we were going to win, launched an advertising campaign that was ready to go as soon as the decision came out. And so that involved ads in the newspapers, on the radio, and on TV, which I would have thought was very expensive. And it certainly was a formidable issue that we needed to face. At the same time, some churches sponsored a mail-in campaign to encourage the government to invoke the notwithstanding clause. I should add that's not all churches, and in particular, the United Church of Canada was a very strong supporter of Doug and Vriend throughout this process, and in fact was an intervener at the Supreme Court of Canada hearing in favor of Delvin's position. So there were calls for the invocation of the notwithstanding clause on call-in radio shows, letters to the editor, and the government was flooded with these calls to invoke the notwithstanding clause. There were also letters on Delvin's side encouraging the government not to invoke the notwithstanding clause, but clearly less well-organized and funded. However, Delvin had the support from unions, a number of unions, including particularly the nurses and the teachers' unions, both of which were tremendous allies. And quite apart from the public pressure, there was really strong pressure on the Premier to invoke the notwithstanding clause from certain individuals within his own cabinet and his caucus.
What was your sense of the public's attitude towards the notwithstanding clause at the time? Would its invocation have been considered an extreme step?
Well, honestly, I expect that most people hadn't given it much thought. Up to that point, it had never been invoked by an Alberta government, and then, as now, it had never been invoked by the federal government. However, very shortly before the decision of the Supreme Court of Canada in Vriend, the Alberta government introduced a bill to limit its liability arising from its eugenics policy of forced sterilizations that had occurred from the 1930s up to the 1970s. Alberta was, again, seeking to limit its liability, and in order to do so, in the bill, it included the invocation of the notwithstanding clause. And that led to public outrage. And as a result, the bill was abandoned, it was never passed, and the notwithstanding clause was not invoked. I think that incident, shortly before the Vriend decision, led to significantly more public awareness about the existence of the notwithstanding clause. But I also think that the Alberta government, because of that experience of having introduced the bill that it then needed to withdraw, was nervous about the issue of invoking the notwithstanding clause. They were recognizing that there could be significant political implications of doing so. So I would say at that point in time, the invocation of the notwithstanding clause was not viewed as a routine political tactic. However, that being said, there were some people, both within the government and in the general public, who thought that the decision of the Supreme Court of Canada in Vriend constituted one of those exceptional circumstances that would justify invocation.
A week after the Vriend decision was released, the Klein government decided not to invoke the notwithstanding clause. You spoke about this earlier, about how there were political implications for invoking the notwithstanding clause, and the Alberta government was weighing those considerations. Why do you think that they ultimately decided against invoking the clause?
Well, I think the starting position was the Premier was under very strong pressure within his own caucus and within his cabinet. And again, he had been buried in letters that were encouraging him to invoke the notwithstanding clause. But the Premier started to read some of the letters that he was getting. And he said later that he was appalled to see the level of discrimination and hate set out in some of those letters. And he said that he came to the realization that the gay and lesbian community in Alberta really did need protection. And it is my understanding that that was the determining factor for him. Now, having decided himself that he did not want the government to invoke the notwithstanding clause, He then had to deal with his own cabinet and with his own party, which was not, I think, an easy undertaking for him. In the end, however, he did manage to survive and to gain the support of sufficient number of members of his caucus in order to stay in office and to avoid invoking the notwithstanding clause.
What was this week like for 2S LGBTQIA plus community members and advocates with their judicially recognized rights essentially hanging in the balance?
Well, first of all, I would start by saying it didn't feel like a week. It felt like at least a month. Looking back and realizing it was only a week, I have to say that's pretty astonishing, because it seemed like a fairly extensive period of my life. I would describe times as, in two words, frightening and exhausting. Over the course of that week, Michael Fair, who was Alberta's first openly gay politician, was the subject of death threats, and he was placed under police protection. More generally, for the entire 2S LGBTQ community, the message by those seeking to invoke the notwithstanding clause was, 1, we don't think you are deserving of these basic human rights. And 2, we demand the right to discriminate against you because of your sexual orientation. And we think these issues are so significant that we should override the fundamental human rights that are guaranteed to you under the Constitution. I recall later an article in the National Post describing this week as the flames of hate were roaring. I think that's a very good description.
Do you think that public attitudes towards the notwithstanding clause in Alberta have changed since Vriend was litigated? If so, how?
Well, since the decision of the Supreme Court of Canada in Vriend over the last 25, 26 years, particularly over the last few years, we've seen the notwithstanding clause being invoked by various provinces across the country. We've seen it on a number of occasions invoked by the government of Quebec, largely around language and culture issues. We did, by the way, see it invoked by the government of Alberta not terribly long after the Vriend decision, when they passed amendments to the Marriage Act to attempt to make it illegal for same-sex couples to be married in Alberta. Now, it's not a matter of provincial jurisdiction in any event, but they did invoke the notwithstanding clause in support of that legislation. We've seen it invoked in Ontario on a couple of occasions, and we saw it invoked by the Saskatchewan government in respect of its legislation limiting the rights of transgender youth. We've also seen Pierre Poilievre, the leader of the opposition federally, that if elected, his government would use the notwithstanding clause in respect of its criminal law amendment agenda. So I'm concerned that the invocation of the clause may be starting to get normalized. And if that happens, of course, that places the Charter at serious risk. If governments invoke the notwithstanding clause every time they fear that their legislation may contravene the Charter, effectively, the Charter will become meaningless.
What was the greatest lesson about fundamental human rights that you feel came out of this case? And has that lesson been lost over time?
I think the greatest lesson for me was that it's possible for a courageous individual with little or no resources to take on those in power and to win. And that was true of the civil rights movement in the US in the 1960s. It was true of the gay rights movement in Canada in the 1990s. And I believe it's true of the trans right movement here today. So for me, that's the key lesson. But I learned a number of other things as well. First, law has a powerful impact on society. The decision of the Supreme Court of Canada in Vriend not only changed the law, it also changed attitudes. very quickly after the decision came out, people came to realize that society was not going to fall apart if basic human rights protections were extended to members of the 2S LGBTQ community. But in significant measure, that was because the law was changing, had the impact of changing attitudes. Ironically, society has a powerful impact on the law as well. The decision of the Supreme Court of Canada in Vriend came out as societal attitudes were starting to change. And frankly, I'm doubtful that the same decision would have been reached if the case had been heard 3 or 4, or maybe even 1 year earlier. And finally, the lesson for me coming out of this decision was lawyers, and by that I mean all lawyers, I mean the entire profession, not just human rights litigators, have a key role to play in protecting human rights.
Hello, Jack. Welcome to the podcast.
Hi. Thanks for having me.
Today, we're particularly interested in hearing the perspective of advocates like yourself on the discussions emerging out of Saskatchewan and its Bill 137, termed the Parents' Bill of Rights. This legislation requires school staff to obtain parental consent before using the gender-related preferred name or gender identity of a student under 16. The Saskatchewan government invoked the notwithstanding clause to override parts of the Charter. These parts include Section 2, which protects fundamental freedoms, including religion, expression, peaceful assembly, and association. Section 7, which protects life, liberty, and security of the person. And Section 15, which protects equality. So, can you guide us through the arguments people opposed to this legislation are making and the research used to support their views?
The points in which individuals who are opposed to this legislation continually point to the fact that young folks have the freedom to choose and to explore their identities. They should have the freedom in their own schools to be able to do this. You know, this is a rite of passage. Everyone goes through this aspect of exploration. Some of it just happens to be in different means. Some of it is, you know, the fashion that a young person takes on. We've all gone through those not so cool fashionable choices or those not so cool fashionable haircuts, right? That's a part of exploring identity. Now, the aspect is just a little bit more for trans and gender diverse youth in that the exploration of feelings that they have on the inside, in that their own gender does not necessarily match the gender that is being imposed upon them via society that says you're, let's say, born into a body that is supposedly quote unquote female. That way you should then have to dress feminine. You should have to use she, her pronouns. If an individual does not feel that way, they should have the ability to explore that. Now, those are some of the bigger aspects of the opposition to this legislation, is that this legislation is infringing directly on the rights of these young people to explore their identities in a safe environment. And there is countless aspects of research that is out there when it comes to young trans and gender diverse youth in schools, saying that when they are recognized and affirmed and accepted within varying genders that they may be exploring, they feel safer within schools. Now, we can look at some of the research as well that's coming out of EGAL Canada and other organizations nationally that have showcased that some trans youth, up to, I believe, about 75% of those who have not been accepted within schools feel unsafe within these schools. So when one is not able to give their full emotional attention, their full actual cognitive attention to their learning environment, that's when we see a higher dropout rate within trans and gender diverse folks. That's when we see higher depression because they cannot necessarily relate to other students around them because they're having to hide themselves. Now, much of the research points to the emotional well-being of individuals. And I think this is one of the biggest points that unfortunately this legislation did not go into. They did not listen to the youth that are directly affected by not being able to talk about their gender identity and explore it in a safe environment in which schools seem to be the best place to relate to others, to build up community, and to find out who they are as individuals.
A legal challenge has been mounted against the Parents' Bill of Rights. What arguments are your pride making, and how have the Saskatchewan courts responded so far?
I will say that one of the biggest arguments that is coming forward is the harm that is going to be done to trans and gender diverse youth with this legislation. And that youth are having to choose to stay in the closet until it is safe enough for them, whether or not they're leaving their own family environment, whether or not they're leaving their own community. Let's say they're going off to university. Let's say they're moving away once they're done high school or so on and so forth when they come of age. Or are they going to then be outed within their schools and potentially have to go through irreparable harm when it comes to, let's say, guardians or parents or community members that are not accepting towards their trans identities? This is the hard choice that these young children have to make. And this is my own personal opinion, why are we not creating a society where it is available to individuals to be safe in regards to either exploring their identities within schools or potentially having parents that are understanding or a community that is understanding of the struggles that they have to go through. And I think at the same time, once again, my own personal opinion, that parents across this province would benefit greatly from learning more about trans experiences, to learning more about two-spirit experiences, to learning more about the human development stages that take place, and to remove, I suppose, the cis-normative narratives that everyone develops the same way. That's not the case, as we can see with the diversity in human experience.
What role does the notwithstanding clause play in the challenge?
The role that the notwithstanding clause plays in this challenge is that when the legislation was first brought forward and was moved along the court system, I believe it was at the Supreme Court that recognized that this is actually going to potentially violate the charter rights of individuals. And it was then that the Saskatchewan government decided to invoke the notwithstanding clause in a way that, regardless if this legislation did harm individuals, that it didn't necessarily matter, that the legislation was going to be pushed through regardless. So they subverted the court systems. They subverted the discussions that should happen. They subverted the community consultations that should have taken place in hearing from community members and the general public. For this particular legislation, the great concern is how the government of Saskatchewan had received information from the public, which essentially was just a couple handfuls of letters that came through from quote unquote concerned citizens. And it was through these couple of handfuls of letters that the government of Saskatchewan based this legislation on. Now, when the legislation was pushed through, it wasn't necessarily taken to the general public to get feedback on. So that being folks who are trans, folks who are two-spirit, folks who are part of the general 2S LGBTQ community were unable to give feedback or consultation with the government of Saskatchewan, which is of grave concern when we look at the direct impact on said individuals in the community of those identities.
When rights-infringing legislation is passed, it can put extra pressure on the supports available to people from affected communities. Can you tell us about organizations such as Trans Sask, Queer Momentum, and Justice Trans, and the effects the Parents' Bill of Rights has had on them? Did the use of the notwithstanding clause have an additional impact?
For organizations within the province of Saskatchewan, I believe many were not surprised that our current Saskatchewan party government would utilize the notwithstanding clause. Yes, it is one of the last resorts that any government should be utilizing. Yet this one decided to take the last resort as their first resort. And to showcase the fact that 2S LGBTQ organizations in the province were not surprised, I think just goes to show that the challenges within this current Saskatchewan party government have been there for a number of years, and the organizations have seen those. We've seen the unfortunate anti or 2S LGBTQ negative viewpoints that have leaked out from our Saskatchewan party. And one of the surprising factors that has really sprung out of this is that our general public are now aware of these things through the Saskatchewan party government utilizing the notwithstanding clause. I think it came as a surprise for the general public that the government would go to the last resort as their first resort. But for the organizations, no surprise. As we heard this, we heard it was coming down the line, and to see that the government would listen to a couple of handfuls of letters sent in that gave anti-trans sentiments was not something that came as a surprise. Now, when it comes to the support systems that are in place for 2S LGBTQ individuals, youth, adults, and even allies and parents of these individuals, is that there is now quite the pressure on these organizations to offer support, to offer direction, to offer specific speaking points that can be brought to community members for general public citizens to speak with others at the coffee shop, to speak with others at their church groups, to speak with others at their soccer games. They want to know how to help. And I love the fact that that is one of the biggest pressures coming on to 2S LGBTQ organizations right now, is from allies asking, how can I help create a better Saskatchewan for all people, especially those vulnerable trans youth?
So, Section 33 tells us that the notwithstanding clause invocations last for a maximum of 5 years. Within that time, an election will take place, and the incoming government can choose to re-invoke or let the law fall. Can laws that violate the rights of marginalized communities have lasting impacts on these communities, even if they're only in effect for a relatively short period?
The lasting effects of these laws certainly can and will have irreparable harm in some communities, because there have been folks who heard from the current Saskatchewan party government that their views of anti-trans are okay, because it came from leadership in our province to say that anyone who's young and exploring their gender identity or gender expression should not have the freedom to do that on their own and should consistently be subjected to potentially harmful scenarios. These sentiments are what we've been hearing in certain communities. And parents certainly should be involved in the raising of their child, should certainly be involved in those spaces of support, of affirmations. And the challenge that we're seeing when it comes to what will happen over these next few years is being able to have conversations with parents and community members who have held these deep-seated anti-trans or trans-negative viewpoints, and to bring in the human element to this conversation, that we all deserve the freedom to be who we are. We all deserve the freedom to explore ourselves, because at the end of the day, there is no harm in being able to explore one's own identity. There is no harm in being able to be affirmed in one's identity. In fact, there is power in those aspects. There is celebration in those aspects. There is joy in those aspects. So as we look at these next few years and sorting through the emotional baggage now that is placed upon our communities here in the province of Saskatchewan, I'm hopeful that education is going to lead us to a brighter future, that education and the human element around these discussions are going to open up so many doors for individuals who may not have, prior to this legislation, been aware of trans people in their communities, that have been aware of the trans experience, that have been able to actually meet individuals such as myself who are trans, and seeing that I'm just like any other Joe Schmo. I love the writers. I love a good poutine. I love a good camp out over by the lake. I am just like you. I'm your neighbor. I'm your friend. And I'm a citizen here in the province of Saskatchewan.
What lessons should Albertans and Canadians in other jurisdictions take from the Saskatchewan experience?
I find that the Saskatchewan experience can highlight the fact that conversations need to happen in governments and with community. Conversations are the great building blocks of society. And for governments such as the current Saskatchewan Party here in the province of Saskatchewan, for them not to have these conversations just goes to show how brittle this particular bill was and is. And I hope that other spaces in our country recognize that having these maybe challenging conversations are vital, and lead into it, lead into some of the challenges that are going to present themselves, because people have differing viewpoints. But for a government to take it upon themselves to try and legislate the human experience and the way that people should be walking around in society, that's of grave concern. I am hopeful, though, that this unfortunate time, this unfortunate hiccup in the province of Saskatchewan's history is just that. It's a hiccup. And that we will get back on track in standing up for our neighbors, in being great allies to one another, and recognizing that everyone deserves the freedoms to be themselves.
Thank you so much for your time and expertise, Jack.
Thank you.
This takes us to the end of the episode and the end of our brief 4-episode dive down the Section 33 rabbit hole. What doesn't end, though, is the controversy over this unique and increasingly active part of our Constitution. As I'm recording this outro, litigants are making submissions to the Supreme Court of Canada in the Bill 21 case, and the litigation on Saskatchewan's pronoun policy isn't far behind. Moreover, in the last 6 months or so, we've heard fresh rumblings from Quebec and Ontario, with both provinces suggesting that they're prepared to use the notwithstanding clause to deal with issues that it hasn't yet touched, including the rise of homeless encampments. The upshot of this is that this series hasn't told a complete story, but has provided a snapshot of a story that's still being told. Through the courts, through legislatures, and through lively public debates. We hope that some of the expert analysis you've heard here helps you figure out how you want to figure in this story, and how you feel about Section 33's distinctive approach to rights protection. Thanks for your interest, and thanks for listening.